All right, everybody, we're going to get started. Thank you so much for joining us today. I'm really thrilled at the turnout and you all taking the time to be here. We've been wanting to offer this as a resource for some time now, and we're very excited that Jocelyn's agreed to help us out with this. We know there's a lot of individuals on this call that are eagerly seeking information and to expand their knowledge on landowners' rights and industry standards for that. This meeting is recorded, so if you guys wish to not be recorded, feel free to keep your cameras off. I see everyone is muted. Everyone's going to stay muted until the end. We're going to have Jocelyn go over everything for about 40 to 45 minutes and then leave about 15 to 20 thereafter for questions. If you have any questions, you can feel free to put them in the chat and we'll address them afterwards. And we will be uploading this video onto our YouTube as well. So if you are needing to jump off early and you don't want to miss anything, we will be uploading it to our YouTube the following week. So without further ado, Jocelyn Phares is going to introduce herself and get started.
Thank you so much, Krista. Hi, everybody. I'm Jocelyn Phares. I have an environmental law degree from Lewis and Clark. And I've previously worked for the West Virginia Division of Natural Resources as the Federal Energy Regulatory Commission coordinator. I do want to preface this by saying that I am not a practicing attorney. So, as always, please take your specific questions and circumstances to an attorney before formalizing any agreements or making anything official. This class is intended to really be kind of an educational and give you a lot of information. We will end with some success stories and as well as some resources for you to potentially use in your own circumstances and battles that you're handling. So, without further ado, I'm going to get started. We're going to start out with some basics of property law. I think it's really important to start out with that because you need that as a background before we get into eminent domain and really where that comes from and your abilities as a landowner and property owner when it comes to eminent domain. So I can't see you guys. I know you can see me. I can only see my screen. So I'm going to start moving through the slides. If you need me to slow down at any time, please reach out to Krista through the chat, and she'll let me know that I need to slow it down a little bit. All right, so here we go. So property law basics. So basically, property law is sort of considered this bundle of sticks. And my favorite analogy for this is if, let's say, you're building a fire, right? And you only have like 2 sticks. You can't really build a fire, but maybe your friend has 3 or 4 sticks, and together you can build a fire and you share that fire and the warmth from that fire together. Let's say you have 6 sticks and fire starter, and you can build your own fire and you don't need anybody else's help to do so. So that is your fire. Property law is separated into specific rights, and this is called a bundle of sticks. There are 5 core rights that you have as a property owner, and we'll go through these individually, but they're the right of possession, the right of control, the right of enjoyment, the right of exclusion, and the right of disposition. And so when you own all 5 of these, you're really, really strong, powerful property owner. When you only own maybe 2 or 3, there are other weaker spots in your own property ownership. So that's one of the first things that we cover in property law. So the right of possession, this is the right to physically occupy and hold property. You might often hear possession is 9/10 of the law. And this is a really strong stick, a really big stick in your bundle. So for example, you sign a new lease agreement, a tenant moves into your apartment. You've temporarily transferred to that tenant the right of possession. They now occupy or possess the space, even potentially against you as the owner, depending on the terms of that agreement. So the right of possession is really strong and powerful. If you're possessing and occupying that property, the law sees that as really valuable. So the next bundle stick in your bundle is called the right of control. So this is your ability to manage and use your property however you want to, as long as it is legal. It is oftentimes the one that is the most limited. The example I've given here is kind of silly, but the right to build a fence around your garden or paint your bedroom purple. The right of control is often limited by other people's property rights as well. Um, Additionally, you can think of, for example, if you're in an HOA, right? This is a really common example where you would see your right of control limited by the terms of joining that HOA. So the right of enjoyment, and this comes up a lot. People talk about this a lot, particularly in public nuisance law. But the right of enjoyment is the right to peacefully enjoy your property without interference from anyone else. It's the right to be free of nuisance. And it's really easy to get this kind of thought pattern in your head that, oh, this is my right to be happy in my property no matter what. That's really kind of the wrong way to think about it. It's more, I am free of infringement. There is no one else's action that is infringing on my enjoyment of my property. So, really, you think about this with noise complaints, right? Like a college student is throwing a party that's really loud around you, and that is limiting your enjoyment of sleep in your own house. So, police are going to come by, law enforcement's going to come by and shut that party down. This is a really typical way of thinking about this and a really simplistic way of thinking about this. This does come into some kind of complex case law, particularly when it comes to environmental law, and as far as pollution and the way that works. But we're not really going to get into that too much today, unless you guys have specific questions about it. The next right is the right of exclusion. This is, where you come up with common no trespassing signs. So it's the right to decide who and what may enter your property. It allows you to defend your property. And this is where we commonly think of not being able to have your property searched unless there's a warrant, right? A legal warrant. This is a really powerful stick in your bundle as well, but it is not absolute. And it is where we see eminent domain come into play most frequently. And then there's the right of disposition. And so this is the right to transfer your property to someone else temporarily or permanently. This includes leases, trusts, wills, sales, and gifts. I'm going to give you kind of like an oddball example because it was something that teased my own brain. So, for example, you decide to rent your property on Airbnb. You're temporarily transferring that property to Airbnb and thereby its customers. So it's actually set two transfers within that example. And I think that's a really interesting one to use. Okay, so now we're really going to get into it, you guys. So the takings clause and eminent domain. And really when we think about what is eminent domain and where does it come from, we're thinking about the takings clause. And eminent domain, right, as we know it, is the right of the government to take private property. So this comes from the Fifth Amendment of the U.S. Constitution, and it provides that private property shall not be taken for public use without just compensation. Now, that is italicized on purpose because those are the definitions within the takings clause that we see kind of come out and argued about and debated quite a lot. So be taken for public use without just compensation. This is otherwise known as the takings clause, the Fifth Amendment takings clause. And it's interesting, in 1875, the Supreme Court found that this right is of the government, the right of eminent domain is not explicitly given in this clause, right? It's not saying, oh, the government has the right to take private property. Really what it comes from is an implied assertion that, without saying that there is a right for the government to take private property with just compensation, right? So the government cannot take private property for public use without just compensation isn't giving the government an explicit constitutional right to do so. It's implied. And that has come up before under the Supreme Court a few times. However, the Supreme Court has consistently maintained that this is implied and has developed case law to make it so into modern day, the legal system in modern day, which has become the doctrine of eminent domain as we know it. So, what is public use, right? If we go back to that slide again, private property shall not be taken for public use without just compensation. So there's a clarifier on that statement. So, what is public use? The Supreme Court is really unwilling to provide limits on public use in the case law, and they really want Congress and the legislative powers, whether that be federal or state, to decide that. The concept of public welfare is broad and inclusive. This comes from a 1954 Supreme Court case. And they made that really liberal. They said it could be spiritual, physical, aesthetic, or monetary, what that public use could be. And they really wanted the community to determine what that could be. In 2005, this came up again in a really interesting case that kind of developed eminent domain and property law a lot further, in saying that even if it's an economic purpose, economic development qualifies as a public use because it serves the purpose of increasing jobs and tax revenue. So when this case was decided, it's actually really significant to note that several states came out with amendments to their constitutions to limit this holding by the Supreme Court. Because when you think about it, it's a pretty dangerous slope to go down. And even in some of the dissent on the Supreme Court, the dissenting opinions stated that, condemnations of individual properties that are transferred to other private parties, so not a public state but a private party, would raise a suspicion that a private purpose is afoot. So they're alluding to corruption under this dissenting opinion from the Supreme Court in this case. So other than that, though, the Supreme Court has not really come down with a definitive ruling on what public use is. So it's really left up to the legislature. Unfortunately for private property owners, there is no bright line rule on what that means. This kind of, oh, so this slide the title didn't quite work out, but the 14th Amendment and just compensation. So what protections are there against eminent domain? And really, your protections against eminent domain come from the 14th Amendment's due process clause. Again, this is the same clause that prevents illegal search and seizures, and it mandates that property owners receive adequate notice and an opportunity to be heard before property may be taken. Now, adequate notice is pretty easily covered, but the opportunity to be heard has often come into play when eminent domain cases has come up, that there wasn't any meaningful opportunity for a citizen to argue their case against a federal or state agency initiating an eminent domain action. Another protection comes from the takings clause itself, and that requirement is that of that just compensation. Just compensation has universally been interpreted as fair market value. However, there is case law that kind of runs against this, saying that not only should it be fair market value, but it needs to return the property owner to the same financial position as if the taking had not occurred. So what that means is, like, let's say a federal natural gas pipeline is going through your property. If that has devalued the fair market value of your property, the planning that's been years in the process, that piece of property has been damaged financially by that government action, regardless of whether it is occurring at the same time as the eminent domain action. So that's some sticky situation in the case law as well, and gives property owners a little bit more protection and leeway against being financially ruined by eminent domain. And so I think it's really important to remember that when you're in an eminent domain case, regardless of when the eminent domain action is instituted, there was a time when the government action was slated to begin, and whatever your property value was before that would be the same financial position as if the taking had not occurred. So that's kind of been debated out in the case law, and it's been ruled out as differently. Rulings have come out differently under different circuits, but that is definitely a stick in your bundle, so to say, for property owners. So that just compensation obviously comes down to what a property is worth. This is the most hotly debated topic at issue in eminent domain cases. And what really happens is when a government agency argues that there's only a partial taking of property and therefore full compensation is not necessary. So that's really hard to hear. But typically, what we think of in eminent domain cases, or at least I did before I went to law school and took some classes on it, is that the government's coming along and taking your property for some public utility, and they're going to give you a offer on your house or your piece of property for it, right? And you're going to take that, and then that's eminent domain, said, done, hands cleaned, right? It's not always like that. So sometimes they're going to put a telephone wire through a piece of your property, and they're going to argue that you're still able to occupy or possess, right? The right of possession. So you're still only able to, since you're still able to occupy that piece of property, the taking is only partial. So they're only going to compensate you for whatever the value of that partial taking is. This, counterintuitively, you might then want to argue as a property owner that rather than there being just a partial taking, that there has been a full taking, because you no longer see the same financial value out of your property that you did before the government action occurred. And this is really, really, really where you want a really fantastic property law attorney to handle your eminent domain case, right? Particularly in the instances of property valuation and really specifically in partial taking cases. And that's where we see a lot of people affected by eminent domain when there's a partial taking. So, like, when I first learned about this, it was kind of counterintuitive that a property owner would want to argue that there had been a full taking for eminent domain, but it comes up a lot more often than you would think. And this is called inverse condemnation. So when a property owner institutes an action against the government, arguing that their property has been taken, right? This comes up, like I said, with partial takings cases most often. So what constitutes a taking, right? Physical occupations may constitute takings, even if it's small, even if it's temporary, or even if it's a government regulation, even if the legislature has made a law that then affects the way your property is occupied, that can then be considered a taking. And most importantly, for economic or regulatory actions, we really see a lot of cases come into court about if it's a taking or not, right? That's when the question really becomes crucial. And the courts have created a balancing test to determine whether or not a taking has occurred in instances of purely economic or regulatory action. This is called the Penn Central test. I'm not going to get into all the specifics of this case, really. We could talk about that for a really long time. So, but for regulatory takings, the Supreme Court decided that there are 3 factors that you should consider when determining whether or not a taking has occurred when that government action is economic or regulatory. So the 3 things that a court will consider are the economic impact of that regulation, your interference with investment-backed expectations. So let's say you were flipping a property, right? If this action came into interference with what you had anticipated being able to flip that property for, that could be an argument for that. or the character of the government action, right? So is it really for the public benefit? Really is what that's saying. Um, Property owners have a difficult time with inverse condemnation cases when it comes to this test. It's very difficult to prove. However, in Lucas versus South Carolina, the Supreme Court ruled that a deprivation of all economically viable use will constitute a regulatory taking. Now, I've highlighted and bolded all because it is very specifically only if all of your economically viable use of your property has been taken will it constitute that way. So, when we're talking about economic and regulatory actions, it becomes much more complicated than just a physical occupation of property. So really where that's the my little property law basics eminent domain introduction that I'm going to give you. There's a lot more there. That's not it. That's not the extent. That's like the 101 crash course in property law and eminent domain. Where my area of expertise, right, because I'm not a practicing attorney, my area of expertise is negotiating prior to legal action. So in my work with the DNR, I oftentimes was working with private industry as the state representative and really ensuring that our public resources, for example, our wildlife, our wildlife, our water, those kinds of resources, our timber was being protected and mitigated in the best way possible or restored, whatever needed to happen to ensure that those resources were damaged as little as possible or restored to their value. And this I saw most often with natural gas pipelines and wind turbines. And so in my role, I was often not just negotiating with industry for the state, but also negotiating with landowners in the state and at times negotiating with landowners as a state representative with industry. So there were a few different ways that I worked in this field as a state representative, and this was all prior to legal action, right? So my area of expertise comes before you go to court. So my 4 rules for landowner negotiations, and I would say that these go across the board, whatever the kind of government action you're looking at, whether that's regulatory, physical, or economic, whatever kind of taking you're dealing with. My first rule is do not take the first offer you are given, especially without consulting an attorney first. Do not be scared by aggressive languages or notices. Their goal is to intimidate you. That is the goal. That is absolutely the goal. And so the first offer you're given is oftentimes a lowball offer, even. They're hoping that you'll take it and be scared. And this is just strategy that's used by industry and the government often. So that's the first rule. Do not take the first offer you're given. And second rule, if you wish to avoid a complete sale of your property for whatever reason, we talked a little bit about this when I was talking about inverse condemnations. Maybe you do want the government to rule that there has been a taking on your property. That might be the best financial strategy for you personally. Maybe you don't, right? Maybe you do want to hold on to that property for whatever reason, and you would rather not sell it. So there are alternatives, alternatives such as leases or easements. There are options. They could be temporary. And really, this is where I saw a lot of leeway and flexibility from industry come in. They would rather stay out of court. They don't want to go to court with you, but they're willing to be flexible. So when you're creating a lease or an easement with a industry partner, let's say it's like, I don't know, this is a made up one, but like Butterfly Gas, natural gas from, I don't know, Colorado wants to build a transmission line through your property. So you want to make an easement for them to do that. You don't want to sell the property totally. And in that easement, you're able to kind of get a lot more specifics of what you want than you would even necessarily if you'd taken it to court. And this leads into my third rule. So define the compensation that you want, right? Like you're able to do that, particularly if you're doing a lease or an easement. You can say, I've seen landowners while working with the DNR, I saw landowners who would negotiate lifetime royalties, for example, or even in one specific case I'm thinking of, they negotiated with a gas company to run a direct line of natural gas to their house. So they had, free natural gas for as long as they were occupying that property and as long as that line was there. So there's like some alternatives there that I think are not as often looked at, and you can really define those things. My fourth rule specifically is to remember, people forget about this all the time, but remember to discuss the mitigation and restoration of any harm done to your property prior to formalizing any agreement with all parties involved, whether that's industry, state, or federal. I've seen, again, in my work with the DNR, I saw some really horrendous cases of private landowners' properties not being restored to what it was before, and that burden then being put on the property owner, which is really a shame and in my opinion, unjust. So I think it's important to remember that when you're using an alternative, you really want to make sure that you have terms about mitigation and restoration in there. So this leads me to some maybe some happier stuff. I want to discuss some success stories with you guys. These are eminent domain specific success stories, not just negotiations. And I want to talk first about, we're going to talk about Payne County, Oklahoma. So this was a case from 2025. Payne County SOS is a grassroots organization that was fighting a high voltage transmission line. And really what this came down to is they were able to prove that the nature of the action was private profit rather than public use. And that's, like I said before in that case, maybe I can go back a little bit here. In this case, Kelo versus City of New London, there's a slippery slope, right? That even the Supreme Court dissenting opinion realized here that you can see a lot of corruption could potentially occur with this ruling. And so this case in Oklahoma really was able to prove that the private company was benefiting and it wasn't a public benefit. So there's that case. And then in James Island, South Carolina, this is an interesting case. This was recently happened. And this was the Gordon family. So this wasn't really necessarily a grassroots organizational effort. This was a specific family. And really what they were able to do is there was a park project that the city wanted to put on their property. And they were using a private developer, and the state actually, they were able to raise enough media attention and community gumption, and I guess is the right word I'm looking for, to determine that eventually there was a legislative effort in the state that amended their constitution to limit that holding of that new Kelo case that was, again, at issue in Oklahoma, that economic extension for public use. And then in Lakewood, Ohio, this was a little bit earlier. And this is a little bit more typical of what we think when we think of eminent domain cases. But in this situation, the city had decided that they wanted to build like condos and a new strip mall over this neighborhood, and they determined that all of these houses in this neighborhood were blighted. And for example, some of these reasons were there wasn't a 2-car garage in the house, so the house was labeled as blighted. And really what happened was, again, there was enough of a grassroots effort to create a new legislative or a new law that defined what it was to be blighted. They came up with a bright line rule about what blight meant for a house and condemning it, and the legislature then voted on that, and it became the city was no longer able to put that condo and strip mall there over that neighborhood. So as we see with all of these grassroots success stories, really what's happening is it's coming down to that economic use. That was the new Kelo case in 2005 that kind of like extended that public use to being an economic use as well. And we're seeing legislatures and state legislatures create limitations to that ruling specifically. And we see this a lot in conjunction with, right, the judiciary and the legislature. We see this happen quite often where the judiciary is unwilling to give a bright line rule and then leaves it up to the legislature to create one. But really, the legislature isn't going to create one unless there's enough public outcry about it. And all of these cases were successfully able to do that and make that happen. So it is heartwarming to see that this can occur. So again, this is commonly we see these strategies happen. You want to gather information early. You need to organize with allies, not just locally, not just in your neighborhood, but regionally and hopefully nationally. You want to be able to really get awareness out there. Make sure the public is aware and educated on whatever issue you're dealing with. And then lastly, you want to sustain as much media involvement as possible. It's really important to really get the recognition and the news out there that what's happening is unfair or unjust or whatever the argument is. And then down here, I have linked a resource for property owners. This is Institute for Justice's Eminent Domain Abuse Survival Guide. I think this is highly useful for private citizens in their own struggles. And it's kind of it's going to be a lot more informative than my 45-minute class for sure, but it will hopefully help you with your specific issues. And so I'll link this. I'll have Krista link this into the chat, or if I can, I will. So, all right. I'm going to stop sharing my screen now. If anybody has any questions, I'm really happy to start taking them. We can start the Q&A.
Jim earlier had commented in floodplain restrictions. Jim, could you elaborate on that a little bit?
Sure, thanks. As you were going from those first few or through those first few slides, I was thinking of examples for each. And sometimes those regulatory changes catch people by surprise, and you suddenly can't use your land the way you did when you purchased it. And it just led me to a more general question about calculation, like if there is a 200-foot right of way through your property, is it a simple calculation of acreage and those kinds of things to establish the change in value?
Yeah, so they're gonna try. It depends on right, like it depends on your specific circumstances every time, as I'm sure you'll often hear when you're talking about the law, like it depends. It's like the common answer that you're given. But yeah, they're gonna give you, particularly the industry is gonna want to make it as consistent as possible across the board. So it will come down to kind of how far that infringement is into your property, and maybe that's acreage, maybe that's by square foot. It will come down to something like that, particularly with pipelines and transmission lines that do have these right of ways that are really well defined, and lines of disturbances is what they're called, LODs. So like when that happens, that does become really specific. And the industry itself is going to want to make that as consistent as possible across the board for their own purposes.
And of course, that's just a straightforward measure of acreage compared to when people start talking about view sheds and things like that. If suddenly your view of the cliffs across the river are interrupted by a big power line, that changes the value of your property in a different way.
Yeah, absolutely. So, and this is where it becomes a little bit more sticky, and where I would recommend people absolutely consult a property law attorney specifically, because when you're coming to property valuation questions like that, it can be really difficult to argue something like a view shed, but at the same time, we all know that will impact the economic value of your property, and so you really want a really great attorney to be able to handle that for you.
Thank you.
Yeah, of course. Thanks for your questions.
Thank you, Jim. Does anybody else have any other questions? If you're unable to add it into the chat, feel free to unmute yourself.
Okay, can you hear me?
Yes.
Okay, I'm George. I'm Miriam's husband. There's a big solar project that's going on around us. Eminent Solar Company has leased originally 3,000 acres, and now they've cut it back to about 1,500 to 2,000. But, one of the major property owners, their father bought the property and sold off building lots around the edge of the property, and people built homes there, with the view. And now the son who inherited the property has put in 20 to 22 mega chicken houses to start with on the far side, but it's probably over 1,000 feet from this property. But now they're talking about putting solar panels on the rest of it. And I think that the people in that development deserve to be compensated for their loss of view shed, as well as any activity from the noise and lights from the poultry houses.
And the health.
Right. So you would definitely be dealing with like an inverse condemnation case, right? Where you're arguing that there has been a taking that has occurred. And like I said, we see this come up quite frequently in eminent domain cases where actually the property owner is instituting the eminent domain case, saying that there has been a taking. And when it comes to things like the economic value of a view shed, or whether that's your right to enjoyment, right? Like the nuisance law, that could also be argued. I'd say the best advice I can give you is to make sure that in your development there is unified agreement amongst property owners on that. That is really powerful when it comes to the legal system, to have a combined effort of affected property owners, right? When there's more than just one.
Right. There's probably 10 or 15 houses affected. So
yeah,
I mean,
so if you guys can all come together, and then that becomes much more powerful and persuasive.
Okay.
Thank you.
Yeah, absolutely.
We had another question in the chat that shortly followed that. And then, Jim, did you have I see your hand raised. Did you have a question related to that specifically? Oh, you're muted.
It's probably distinct. Please take that other question first.
Okay. Tylee asked, do property laws vary much from state to state? Maryland, West Virginia, Virginia, to be specific.
Yeah, they absolutely do. So, and in particularly, you will see differences between West Virginia and Virginia's property laws. I'd say Maryland and Virginia are probably a little bit more similar. West Virginia notoriously has some pretty weak property laws for private property owners. The state really does seek to benefit industry oftentimes. So I don't know specifically what the differences are from state to state, but it is really important to make sure that you are looking at your state laws, not just federal ones. So everything I went over today was federal. That was all Supreme Court cases, and those obviously affect the way rulings will be done in states. Like they will follow that precedent set by the Supreme Court, your state courts, but the state legislature might interpret those rulings differently, right? So South Carolina, Pennsylvania, New York, they've all since that new Kilo case came out with legislation to limit that holding on economic use being a public benefit.
Jim, your question?
Thanks. How do right to farm laws work in maybe a context where for the last 100 years, land has been used for grazing animals, and then people buy property around it, and then they install a large pig facility or a poultry facility, which is a significant difference in everyone's experience.
Yeah, so that would be under probably land use, and I'm not totally as well versed in that specifically. But I would say that the right to farm, I would think that it would determine state by state, and this is me just coming out with my like thinking off the top of my head, but it would come from state to state what their farm bill interpretations are. So there's a farm bill, like a federal farm bill that comes out. I think the last update was under Biden, or maybe even more recently under Trump. Sorry, anyway, that's like, but under the state then legislates that farm bill itself, right? So I would think that the determinations of agricultural land use would be defined under each state's interpretation of the farm bill.
Got another question in the chat. If there's an existing ROW easement, is the current property owner out of luck trying to fight transmission expansion?
This is a really, really great question. So thank you for asking me this question, because yes, the current property owner is out of luck as it pertains to that existing easement as it was written. Now, the fact that they're trying to expand that does not, depending on the terms of the specific easement, if the terms allowed for future expansion, that would be one thing. But if it didn't, which most property owners are pretty specific about how, when they're creating an easement, the length, the definition, we're talking about a right of way. So the size of that right of way, square footage, those will be things that are really definitive in the terms of that easement. And if they're trying to expand, you as a property owner are not shit out of luck at all. I would not say. I would say that they would have to revisit or renew the easement if they want to expand.
And then Kylie said, my ROW easement states a double H structure, and now they want to rebuild with a 104 monopole. Isn't that against the ROW?
So, Tylee, for the specific question, I would really need to sit down and look at your circumstances in case. And I do not feel that I am, since I'm not a practicing attorney, I'm not really able to do that for you. So I would suggest absolutely taking your specific circumstances like this and consulting a property law attorney. Yeah, absolutely.
Any other questions? Again, if you're unable to add it into the chat, please feel free to unmute yourself.
Oh, yes. This is Brian Hockman. I wanted to have a question. What you said earlier about sometimes there's a partial taking,
Yeah.
right? So when you go and look at the land and you're basically saying what it was worth before this happened. So are you basically having to go to appraisers and get like before and after type comps to get that stuff, and then you talk to lawyers, or in
I
those
would
type of
say
cases?
anything that you can bring a lawyer ahead of time is great, and absolutely do that. But at the same time, that lawyer, if they're doing their job well, is going to do that work regardless. However, the more appraisals and more information that you have, I would almost say the better. But I would say that attorney would probably do that regardless of whether or not you do that.
Right. And yeah, and when you were talking about, West Virginia, their eminent domain laws being a little wishy-washy, the one thing I did understand, so maybe you can verify this, is that when you actually do go into a eminent domain case and take it to court, um, we were told that you actually go in and you're judged by your peers. Like if you go into a county that you're actually doing the eminent domain, that you will be judged by landowners in West Virginia. You have that ability to do that. So is in cases like that, isn't that more, that's kind of in our favor to help us win this and get a better deal, I guess.
Yeah, absolutely. I think when it becomes a little bit stickier is when we're dealing with eminent domain that is a federal action initiated by a federal action. And in those cases, West Virginia does typically, it's not as strong as maybe Virginia would be. If
So
that makes sense.
if it's a public service commission type of deal where a public service commission gives the utility the right to do eminent domain, then that's not really a federal thing, right? That's more a
Right,
state thing.
right.
Okay. All right. Thanks.
Yeah, absolutely.
And then we had a message from Rebecca. Um, Two, the will be in the best interest of West Virginia customers and its citizens. 24-2-11A requirement for certificate of public convenience and necessity before beginning construction of high voltage transmission lines, contents of application, notice, hearing criteria for granting or denying certificate regulations. This is one of the requirements for approval of transmission line in West Virginia. If the line is not serving West Virginia, how do they have the authority to approve?
Right. So when they came down with that new kilo case saying that economic benefit, they're going to argue that the jobs are economically benefiting West Virginia. So the jobs that are created through that transmission line are of economic benefit to West Virginia. Does that answer your question? I mean, that's what they're going to argue, but
Will they then have to prove that those employees that they're employing are West Virginia residents?
oh, I don't know. That's a really good question. I think that they would have to. I mean, if you really wanted to get into it, I think that's a really good question. But yes, I would think they would have to prove that they're West Virginia residents. I don't know how they would go about doing that, but yeah. And yeah, it is a stretch. I would say I'm reading the chat as well. So they're gonna like that's the argument that the new kilo case puts down. I don't know about the specifics with this West Virginia transmission line, right? But that is the argument that the case law would give you.
And then has anyone ever tried to file a right of
A writ of mandamus. I
yeah.
don't know. Probably I would say most likely, but I don't know the answer to that.
Oh, and then I had a question in the chat. Does the state have their own appraisers? And how is that land value based off of private versus government appraisers, either in and out of court?
So the state definitely has their own appraisers. They're like third party contracts though. And I'm not well versed enough to know who the state appraiser is at this time. But and how is the land value based off of?
So, government comes in
I
with their appraisers and they say, your land, example, your land is worth, this piece of land that we want is worth $20,000, and you have it appraised privately and your private appraiser says it's actually worth 30. So how do you negotiate that? And
the court will they'll so this is really common in case law, and what they'll do is there's a mathematical equation, they'll come down in the middle, right? They'll just meet it in the middle between what the two appraisers are arguing. That's how it goes.
awesome, thank you. Anyone else have any other questions? Okay.
I
This
do
is
not
George
have a
again.
list of
Can you hear me?
attorneys. Oh yeah, go ahead.
Okay. We're in Hardy County, West
Mhm.
Virginia, and it's one of the few counties in the state that has zoning. and this solar company acts like they're not concerned with local zoning laws, but they're going to need to change the designation of their area from part of it's ag and part of it's residential, and have to be changed to industrial. And they don't seem to be worried about that. But to me, we ought to have some control of what goes on in our county rather than going to the state public service district or Department of Commerce and trying to shove this thing through.
Yeah, absolutely. So I think that's typical of industry to not really pay attention to like local zoning regulations until it comes up in an issue in court. But once it does come up in an issue in court, it absolutely will be relevant. And they're probably hoping to have some ability to lobby against those zoning laws or potentially change them in the future. But it is absolutely relevant to your issue. Without knowing more specifics, obviously, I would need to know more to give broader, more specific advice. But
okay, thank you.
Yeah, absolutely.
Oh, and then just going back to Tylee, got a list of attorneys.
I do not have a list of attorneys. Unfortunately, I apologize.
A lot of the attorneys we speak with on a regular basis are specifically for environmental law, industry, and those sorts of things. But definitely do your research. Anybody have any other questions? All right. I think we're ready to wrap it up. Thank you again, everyone, for being on this call. Again, it'll be posted to our YouTube channel, and we'll put some things out on social media so you guys can follow along for that. If you have any other questions thereafter, feel free to contact Jocelyn, and she can either give you her educated opinion or direct you in the right direction.
Thank you, guys. Thank you,
Looks
everybody,
like
for
Mary
coming
Gee put a lawyer recommendation in the chat. Karen Newman, thank you, Mary, for doing that. Tylee's in Virginia. Yeah, we've been working really closely with you all over there. So thank you for being on the call. We hope this helped. We all know that there's a lot of things up in the air right now, which would be a reason you guys would want to jump on and learn more. So we hope to offer more opportunities like this to the public and to our members. So keep an eye out on our social medias for postings on these. I hope everyone has a great rest of their day. Enjoy the Super Bowl, the Olympics, whatever is your vice for this evening. And we'll see you at another West Virginia Highlands Conservancy sponsored event.
Thank you, everybody.
Thank you.